The Court of Appeals Division 1 is now in session.
Thank you. Be seated. Good morning, everybody. Now's the time set for oral argument in cause number 1 CACV 16-0470, Compassionate Care Dispensary, Inc., as plaintiff appellant cross appellee versus Arizona Department of Health Services as defendants appellees and cross appellants. For your information, and I don't think this is going to come as a shock to anybody, these proceedings are being both audio and video recorded, so absent any technical problems, which have known to happen, you can critique yourself on YouTube in a couple of weeks. I think we all know that at this point, but we continue to remind just so you know it's there. Counsel, each side is going to have the normal 20 minutes. We would ask that you respect the time period. The timer located on the podium will let you know how much time you have left. And for the appellant's benefit, if you wish to preserve or reserve any portion of your 20 minutes for rebuttal, let us know. We will do our best not to take up your entire 20 minutes asking questions. Give you a chance to say something. How's that? However, ultimately, your reserving time is going to be up to you. We have this morning reviewed the briefs, conferenced the case, so we are well aware of the facts and issues attendant to the argument. We tell you that, so if you choose to do so, you can fashion your argument around the fact, or if it benefits you, you can fashion your argument around the fact that we have reviewed the pleadings and briefs this morning. Counsel, when you each come to the podium, I would ask that you state your name and who you represent, so the record is clear in that regard. And with that, the appellant may begin.
Good morning, Your Honors. Jesse Callahan with May Potenza, Barron & Gillespie on behalf of Compassionate Care Dispensary, Inc. With me today is Andrew Lishko, an associate at my firm. The purpose of this appeal from the high-level view is that the trial court erred in its construction of a statute under the Medical Marijuana Act. That statute specifically, 362804 B1D. The trial court's error was ruling that a dispensary applicant does not have to submit a sworn statement of compliance with local zoning codes before receiving a dispensary registration certificate. The trial court ruled just the opposite, that the Department of Health Services could issue a dispensary registration certificate, and then later on, a sworn statement of compliance with local zoning could be provided. We know that's wrong because the statute says the department can only issue that certificate if the applicant, past tense, has submitted the requisite document.
Well, counsel, what about the language that says following the issuance of a certificate, the holder must apply?
Following the issue, are we referring to the regulation or the statute? So that is a separate issue. That is the regulation itself. That particular regulation refers to a approval to operate. Two separate things. The regulations at the Department of Health Services require somebody to apply for a certificate first, R917-304. And in order to get that certificate, the applicant has to submit a whole set of documents. Those documents include things such as an attestation that the principal officers have not been convicted of an excluded felony offense. It also includes ARS or R917-304 C5. This is a quote from the regulation that is about applying for a certificate, not an approval to operate. As required in ARS 362804 B1D, a sworn statement. It's important to note that the regulation is referring to a sworn statement as required by the statute, and also referring to an attestation, which for an excluded felony offense, showing a distinction between the two, because later on I intend to present an argument that an attestation is not the same thing as a sworn statement as required by the statute. To answer your question, Your Honor, there are two times that an applicant applies for things from the Department of Health Services before it's up and running as a dispensary. The first thing, the very first step, is that registration certificate. Later on, After the applicant has provided all the documents required for it, the department could then issue that certificate. Once it receives the initial registration certificate, it then applies for an approval to operate. And that's the language that Your Honor is referring to. That is the second part of opening. But the first part, the prerequisite, is that a dispensary registration certificate, in order to receive one, the applicant has to provide the requisite sworn statement. That is required under the Medical Marijuana Act.
Is a conditional use permit required?
Under the Medical Marijuana Act, it does not reference a conditional use permit. What the Medical Marijuana Act has is just one requirement related to zoning, and it is the sworn statement of compliance with local zoning.
So is your position then that the AMA is the only thing that matters, not the AAC?
No, that is not my position. But the AMMA is more important than the regulation because the department cannot act contrary to the Medical Marijuana Act. It cannot violate the statute, regardless of what its regulations provide. It has to stay consistent with that statute.
So when it says that a sworn statement signed and dated by the principal officers of the dispensary certifying that the dispensary is in compliance with local zoning restrictions, there's just a redundancy built into it.
Correct, Your Honor. There is the Medical Marijuana Act requiring that sworn statement, and then the regulation codifies it. The regulation goes on to say, yes, you need to get this in order to receive a registration certificate.
But it has to be done twice.
Under the statute, it has to be done before the certificate. Under regulations, it has to be done twice. Correct.
Okay, so they have to do it before, and then they have to come back and recertify the same exact thing a second time after.
Correct, Your Honor.
Okay, go ahead.
In addition, to go back to the conditional use permit question, the Medical Marijuana Act doesn't say that that's required. The regulations don't say that that's required. But the city says whether or not it's required, and the city is entitled to implement its own zoning regulations, to implement its own zoning code. And so what we have here is the department was confronted with a question. It was confronted with the question so many times that it had to make a policy. It had to take a publicly stated position. What are we going to do here? We have a lot of applicants asking us, can a city withhold the requisite documentation of compliance with local zoning on the basis of an applicant not obtaining a conditional use permit? It came up a lot. So when the department made its policy on that issue, it said, yes, a city can do that. It was a question that was asked so many times they had to post it on their website and say, this is our position with respect to a conditional use permit. We don't require one as the department, but a city is well within its right. And this is what Mr. Patton, the city attorney for Winslow, specifically said in his declaration. The department was asked the question, our city requires a special or conditional use permit before a dispensary opens. Will applicants need a special or conditional use permit in order to get a registration certificate? The first thing, the thing that's at issue here. The department answered the question. The applicant is required to submit documentation from a city or town that the proposed dispensary location complies with any zoning restrictions. A city or town may, however, require a special or conditional use permit for the proposed dispensary location before issuing the documentation of compliance with local zoning. This goes to the so-called two-step process that the department advocated to the trial court, which we know is not true. We know it's not true for several straightforward reasons. The first reason is it would violate the statute. If the department issued a registration certificate without obtaining the sworn statement of compliance with local zoning, it would have acted contrary to the Medical Marijuana Act. And we know from the Cochise case, the department can't do that. It has to comply with the statute. Second, the department's own regulation says that the applicant has to provide documentation of compliance with local zoning restrictions from the local municipality. The applicants were required to get something from the city of Winslow and provide it to the department saying, we comply with Winslow local zoning. The department's own regulation requires that for the first issuance of the certificate. So we know the two-step process wasn't true, but we also know it for the third reason, which is what I just stated. The city determined whether or not it would provide the documentation of compliance with local zoning. And the department honored what the cities did across the state. This is what it told the public, the citizens of Arizona, this is what we will do.
Was there a change in departmental policy that's reflected in our record right about the time of this of these events?
That is correct, Your Honor. Not these events at the time of this appeal. That policy stayed the same until after the trial court, in this case, entered summary judgment in favor of the department. That publicly stated position was the same at all relevant times to this case throughout 2012 and did not change until 2016.
Let's suppose hypothetically that we agree with you that the department said those things that you've quoted to us. Are they bound by that?
They are bound by that, Your Honor. The department is obligated.
Not statute nor even regulation. It's just a public posting.
It is a public posting about how they are treating the applicants. It is an admission. This is how we treated everybody who applied for a certificate that confronted this issue.
Okay, so you're saying that if someone goes out and makes an erroneous statement, and someone can come in and say, well, I relied upon that statement, it's not simply an erroneous statement. They are thereafter stopped from asserting the language of the statute and the language of the administrative code?
Well, Your Honor, what the department's publicly stated position was consistent with the sworn statement. It was sworn statement requirement. It was consistent with the documentation of zoning compliance requirement. The publicly stated position said it's up to the city to say whether or not you comply with local zoning. We're not taking a position on that. And their publicly stated position was consistent with those laws and rules. And that is how they said they treated everyone. That's an admission by the department. This is what we did when we were confronted with this issue, except we know in this one case, with respect to these applicants, the department did something different. Now, we know they didn't have this so-called two-step process for yet another reason. The department actually removed the medicine room from the application process after receiving the letter from Dale Patton, after receiving the declaration from Dale Patton, specifically disavowing that the medicine room complied with local zoning. Mr. Patton said, they do not comply with our local zoning requirements. The department responded consistent with its policy by removing the medicine room from the application process. This is where the arbitrary and capricious abuse of discretion and actions contrary to law came into play. After receiving that proof to the negative that the medicine room does not comply, the department removed the medicine room and then received an email from Dixon Oates, the principal of the medicine room, and said, if you don't put me back in this lottery, I'm going to file a massive class action lawsuit. At that point in time, the department reached out to the city attorney of Winslow on behalf of one applicant to the detriment of another to try to get the city attorney to change his mind and said, hey, we've got this two-step process. We don't need a CUP first. And do you really need a CUP first? Mr. Patton never changed his position. Mr. Patton never said, my declaration was wrong and I take it back. The record is undisputed on that point. The city of Winslow did not provide documentation of compliance with local zoning, and even though the medicine room never went and received it, never went and got it from Winslow and provided it to the department put him back in the lottery anyway.
What should we do if the facts are that the department announced the position you've quoted, then these events began to unfold? They took, I've been calling the medicine room TMR. They took TMR out of the running, and then they interpreted the statute and the regulations the opposite way, because you don't need the conditional use permit for the application for the certificate, and the zoning requirement is a kind of a watered down kind of thing. My words. What's wrong with that if it's a thoughtful decision to interpret differently and to move forward differently?
What's wrong with it is it treated compassionate care and the medicine room differently than it treated all the other applicants, because this is what they said they did with the other applicants. That's the definition of arbitrary, or that's the definition of capricious. The department was obligated to be a neutral department in administering this statute and these regulations.
What if they went forward from that time treating everyone the same as they did here? We're saying there's a two-step process. The requirements are are less stringent in the first step and more burdensome and complete in the second step.
If the department did that, and there's no evidence in the record that they did, but if they did that with respect to the sworn statement, they wouldn't be allowed to. They would be violating the statute. The medicine room didn't provide a sworn statement. That's undisputed.
But once an error is made, the error becomes the law.
The department in this particular case erred in both implementing the statute, implementing the regulations, and in implementing its own policy. It deviated from everything that the law required and everything that it said it was doing in this one particular instance for the benefit of TMR.
Okay, so what you're saying is that once they've deviated, to use your word, that becomes the rule or the law, and that from then on, in order to avoid, let's use the word discriminating, against a particular entity, they have to continue to do that from there on out.
In this particular case, the only evidence is the record is that they only did it in this one particular case. And there's no evidence in the record that they did this special exception for anybody, just for the medicine room. And they maintained this response to the frequently asked question for years after the fact. They never changed their policy. They just didn't follow their policy in this one set of circumstances. Now, if they did actually change their regulations and change their publicly stated position, then going forward after that, as long as it was consistent with the Medical Marijuana Act, the department could do that. But those aren't the facts we have here, and that's not the law that we have here during the relevant time period. I do want to save some time for rebuttal. It looks like I'm about 5 minutes, but I'm happy to answer any questions the court has at this point in time.
Thank you, counsel.
Thank you, Your Honor.
Good morning again. I am Gregory Falls. With me on the briefs is Michael Wright here at counsel table. We are with the law firm of Sherman & Howard, appearing on behalf of the Arizona Department of Health Services and Dr. Kara Christ, its director. I just want to make one thing clear. At no point in the history of the medical marijuana program has the department told anyone that they need to get a conditional use permit. It didn't tell Compassionate Care that. It has not told anyone else that. If somebody told anyone that they needed a conditional use permit, that must have been a city, a town, or somebody like that. It didn't come from the department. At no time has the department deviated from the process followed in the rules, which is there is a two-step process. First, you apply for a certificate. If you get a certificate, then you have a right to apply for approval to operate. The standards applicable to those two processes are different. They're similar, but different.
When does the zoning, requirement of compliance with zoning come into it?
There are two, it applies at both stages. The first stage is when you must certify that your property is compliant with local zoning. Picture that. I'm going to put in a dispensary. I'm going to put it in a single-family zoned subdivision. No, sorry, you don't get it. I'm going to put it in an industrial area. Okay, your zoning is compliant. I'm certifying that I'm compliant. I'm providing documentation from the municipality that I'm compliant. I'm providing a property owner approval where the property owner says, yes, you may operate a dispensary at that location. All three of those are required, always have been, in order to get a certificate. Now, if you get the certificate, picture this. There have been roughly 1,200 applicants so far for certificates. If you get a certificate, only 130 roughly have received certificates. Then you go through the much more arduous process to actually open the doors. Now, if you think about it, if all 1,200 people were required to go through this entire process that council advocates from beginning to end, the waste of resources would be monumental. We would have 1,200 people getting conditional use permits for facilities that everybody knows are not going to open. We would have them getting business licenses. We would have them getting certificates of occupancy. I mean, the entire process would grind the municipalities to a halt. The cities complain enough about what the state does to them. Doing this to them is neither fair nor logical, nor is it required under the rules.
What about Mr. Callahan's quoting of publicly posted policy or information from ADHS that tends to look away from a distinct two-step procedure?
The publicly, it's not looking away from the two-step procedure. The publicly posted process is this. If the city requires you to do something, to certify step one. We're not going to overrule them. We're going to rely on whatever they say. If the city requires a conditional use permit, that's fine. Then they're going to require that before they give you your zoning approval.
So that would become a part of the...
That would, according to an individual city on a case-by-case basis, that might become a part of the first step. Correct.
Was that Mr. Patton's opinion?
Initially, Mr. Patton had that opinion. Well, initially he did not. If you look at the facts, initially Mr. Patton did a letter on May 25, which was right at the end of the application window. Mr. Patton said in that letter, FYI, we want to inform you that our planning person, Paul Ferris, the person authorized to speak for the city, has issued several of these zoning approval forms. Now, the local zoning documentation can come in many ways, and it does. It can be a simple letter from somebody authorized to speak for the city. It can be a form that the department has prepared and posted that is filled out and signed by someone. It can be as simple as current zoning maps and zoning ordinances showing that the location is compliant. In this case, on May 25, Mr. Patton said, we have issued several of these notices. We want to tell you what we've done. There are two properties relevant here. One of them is the 2nd Street property. There are two applicants who got a notice for the 2nd Street property, Green Cross Medical and Compassionate Care Dispensary. There is a third applicant, TMR, who got a zoning approval form for the Mike's Pike property. We want you to be aware of those. But being a careful lawyer as he is, and I would write the letter the same way, he said, we also want you to know, however, that Compassionate Care Dispensary has a conditional use permit. The other two applicants do not. They will need to get a conditional use permit before they open. This came on May 25. The department got that. That wouldn't have raised a red flag at all, and it wouldn't today, because we understand that. You will need a conditional use permit if you're selected and before you open.
So the standard is before you open as opposed to once you apply for the certificate?
We will require whatever the municipality requires to allow you to open your doors.
My point
Yes.
is that if it is going to be required, then it is not a part of the seeking the certificate, but it is a part of the opening your doors, the second aspect.
Correct, unless the city requires it before you apply for a certificate.
So it's up to the city?
It's up to the city.
Okay.
And in this case, Mr. Patton later on, in fact, let me back up. When Mr. Patton sent his letter first, he apparently sent a copy of that letter to Ms. Ward, the attorney representing Compassionate Care Dispensary. She didn't like that letter. She sent him an email message asking him to clarify his letter by saying, you cannot apply for a certificate without a conditional use permit. Why did she do that? Because they were the only ones that had one, and they were the only ones that were going to get one in the short application window, meaning they would be guaranteed a certificate. It's devious, and if it was required by law, they got away with it. The problem is it was not required by law. How do we know that? Paul Ferris, authorized to speak for the city, said these properties are zoning compliant. Patton, he's a lawyer. Yes, he has an opinion, but it's just one man's opinion, the opinion of a lawyer. But we know even more so. Council makes a big issue out of the application of TMR being denied, and there was a threatened class action and all of that. How does this work in reality? You have clerks processing hundreds of documents in a very short period of time. A clerk got the Patton letter, looked at it, got the Patton affidavit, which, by the way, Patton didn't file that. He didn't communicate that to the department. That was something that Compassionate Care did. Looked at all of that, received several emails and telephone calls from Ms. Ward demanding that these other two applicants be thrown out of the process. And a clerk finally said, you know, I'm going to ask these guys what's going on. We may have issued your zoning, your approval, we may have issued that in error. Please tell us why we did not make a mistake. That was the response received from Mr. Dixon Oates. Mr. Dixon Oates logically laid out the two-step process I've just explained and said, our property is compliant, therefore we should be eligible for allocation of a certificate.
Even though they didn't have a conditional use permit.
Correct. And we know Two reasons why we know that was not required by Winslow. Multiple reasons. Ferris issued the approval without 1 to 3 applicants. We've seen...
Maybe he made a mistake.
He might have. We've seen not one piece of legal authority that says in the city of Winslow, before you apply for a certificate, you shall get a conditional use permit. In fact, we cited this below. The issuance of a conditional use permit is actually contingent in the city of Winslow upon licensure from the state. What is the state license in this case? It's the dispensary registration certificate. So actually they're putting the chicken before the egg. In this case, they needed the certificate before they got the conditional use permit. I have no idea how Compassionate Care got one. They should not have. But what happened after these clerks had exchanged something with Mr. Dixon Oates, what happened? A lawyer got involved. Lawyer looked at it and said, you know, he's right. They don't need one now. They are eligible for allocation. And how do we know that? We know that because that lawyer, Attorney General Flores, contacted Mr. Patton and said, there appears to be some confusion here, Mr. Patton. Were you aware of our two-step system? And he said, no, I was not aware, and this is in the email exchanges, I was not aware. If that's the way you do it or that's the way you want to do it, that's fine with me. But be advised, we will want a conditional use permit before they open for business. Again, if you look at 305, that's clearly consistent with the department's rules, so that was no problem at all. That exchange happened sometime in July. Nobody raised any more issue at all. Green Cross Medical and the medicine room were told that they were complete and compliant and they would be in the lottery. 3 people in the lottery. Now, if we go back and look, we were back at the Court of Appeals some 3-4 years ago. Court said in its decision that there were facts alleged in the complaint sufficient to state a claim that the department acted arbitrarily or capriciously or abused its discretion when, 1, it failed to reject TMR's application, notwithstanding its awareness that TMR did not comply with local zoning. I've just explained. TMR fully complied with local zoning. Its property was properly zoned. It had a zoning approval letter. Even Mr. Patton said, oh, yeah, you're right. If they get it, we will require them to come back and get a conditional use permit. That's actually what happened in this case. TMR won the lottery. They came back to the city of Winslow. They applied for a conditional use permit. That application process took about 4 months, a little bit more. There was, and this is in the record, there were the minutes of the Planning Commission meeting where the Planning Commission was considering TMR's conditional use permit. What happened at that meeting? Compassionate Care and its lawyers showed up and argued that TMR could not have one because they had improperly been granted the certificate. Mr. Patton explained, now being the person who understands how the process works, he explained to the Planning Commission, here is how the process works. They did it right. We recommend you approve it. And that was over the objections at that meeting of Compassionate Care. Planning Commission unanimously issued a conditional use permit to TMR, and they were eligible to open for business. The second piece, last time we were at the Court of Appeals, when the department, again, were we arbitrary and capricious, when the department rejected Green Cross Medical's application for lack of zoning compliance, but not TMR's. Again, under the facts, Green Cross Medical and TMR both had zoning compliance. Neither one was rejected. As we explained in the briefs, there was a $150,000 deposit that was optional, not mandatory. And what happened is you could choose to submit your application without that deposit and you would be selected. But if there were competitors in your CHA, if some submitted the $150,000 and others did not, priority was given to those who submitted the $150,000 deposit. What happened here, in spite of what Compassionate Care wants to argue over and over and over, Green Cross Medical submitted multiple applications, but one $150,000 deposit. The department asked Green Cross Medical, where do you want the $150,000? Knowing that where the $150,000 was, that would be a top priority application. Where it wasn't would be lower priority. Green Cross Medical said, put it in the Kingman CHA, not in Winslow. That's fine with us. So what happened was you had 2 $150,000 deposits, 1 no $150,000 deposit. 2 people were in the lottery, compassionate care in the medicine room. Nothing about that was arbitrary, capricious, or in any way a violation of the law. Now, those were the issues in the complaint. That's how we ended up getting the summary judgment process. But now we have this sworn statement argument. And counsel says there was no sworn statement submitted by the medicine room. And his definition of sworn statement, if I read it correctly, is this must be a document sworn under oath, signed by a notary, and a bunch of other things. I'm not exactly sure exactly what it is. If you read the Medical Marijuana Act itself, it doesn't define sworn statement. It just says a sworn statement certifying that the registered nonprofit medical marijuana dispensary is in compliance with the restrictions. That's all it says. Counsel showed up at oral argument on the summary judgment proceedings and cited from the criminal code under the perjury section of the criminal code a definition of sworn statement. That definition is repeated in the briefs. I think it's 27, 29. Anyway, that definition by its express terms applies only to that chapter of the criminal code. It does not apply anyplace else. But even if it did apply, it does what most of us think of when we think of sworn statement in the modern era, and that is it doesn't need to be sworn under oath to God. That's fine if you want to do that, but if you want to affirm, attest to something solemn that shows you're telling the truth, that'll be enough. And how do we know that's enough? Because of the Gear case, which we cited on page 29. Dr. Gear attested that he had reviewed medical records as part of issuing a recommendation for a medical marijuana card to a patient or patients. Prosecutors found out that he was not reviewing these records, that he was falsely attesting. They indicted him for perjury, for false attestation, and were going to prosecute him. That came up to this court, and this court ruled that the import of a false attestation is obvious, and the indictment stands. What did the medicine room say? I, Hugo Dixon Oates, and Abraham Berkowitz attest to the best of our knowledge that we have met all city and state rules and regulations regarding Prop 203, as well as in compliance with local zoning restrictions. All information is true and correct. They signed it and they dated it.
They both signed it.
Yes.
What if they hadn't signed it? Then it wouldn't.
I think the signature is required. In fact, 2 signatures are required because this was, if it's a corporation, Rule 301 says 2 people must sign. As we pointed out briefly in our briefs, only 1 signed for compassionate care. So if anybody failed to submit a proper attestation, it was compassionate care, not the medicine room. Now, apparently the department made an error when it didn't notice that, but if anybody made the false or the wrongful attestation, it was compassionate care. And I just want to address briefly one issue, and that's the standing issue that we raised. Compassionate care has no standing to challenge the award of a certificate to someone else if compassionate care was not entitled to a certificate itself. It lost nothing, therefore it can't stand here and complain that it's been harmed. Our standing issue was something we became aware of right at the end of the case, because that's when we started getting documents as part of the discovery process. Keep in mind, this was pre-answer for about 3 years. They submitted a property owner approval form signed by Mr. Galley and signed by Western Surety. Both of those forms, though, were issued when Mr. Galley was under a temporary restraining order or a preliminary injunction not to interfere with Green Cross Medical. What did they want to do? Throw Green Cross Medical off the 2nd Street property, put compassionate care in that property, and therefore they could run a dispensary there. Mr. Galley and Western Surety did not have legal authority to issue that property owner approval form. They misrepresented to the department that they did, so that was not a mistake on the part of the department. It was a failure of the department in the application process to discover the misrepresentation. But if they have no standing, they have no standing to be here in the first place. I have 2 minutes left, and we had the last word on our cross appeal. I'm comfortable to rely on the briefs there with one comment. We're not asking this court to overturn any factual findings or anything else that happened below. In fact, we ask the court to accept those findings, which are not challenged. And in particular, the finding that we ask the court to accept is the court found that allegations that the department acted arbitrarily and capriciously and abused its discretion are unfounded and without any factual support. That's what the court found. We accept it. They accept it because they haven't challenged it. It's our argument on the cross appeal that that finding, if true, requires some kind of sanction against compassionate care for its action in the case. If there are no questions, that's all I have. Thank you.
Thank you, counsel. Mr. Callahan.
Thank you, Your Honor. Two separate issues are what we have presented for review. One is the construction of the statute. The other is the regulation. One is the sworn statement. The other is the documentation of zoning compliance, which is required by the regulation. The vast majority of the argument today has been devoted to the documentation of zoning compliance, and the arguments just espoused by the department present two issues, two battles here. One argument the department made is, well, the medicine room initially got a form signed by a planner, so it had documentation of zoning compliance. This court's prior opinion specifically states in the Dale Patton Declaration, which is attached to the verified complaint, the declaration itself is under penalty of perjury, that what Mr. Ferris signed was disavowed by the city attorney, meaning that they did not have documentation of zoning compliance. The other battle that we have, and so that's the battle between the city attorney, the chief legal officer of the city, and Mr. Patton. Mr. Patton's signed form came first. The declaration disavowing it. Oh, excuse me, Mr. Ferris's signed form came first.
I didn't mean to correct it.
I appreciate it. Thank you, Your Honor.
Make sure I was following.
And Mr. Patton's signed declaration came afterward, disavowing it. The city attorney interprets the zoning code for the city of Winslow, not a form that was signed in error. The second battle that we have is under a Rule 56 proceeding. The department recited a lot of fact-based arguments. Well, subsequent to that, there was an email. And then subsequent to that, there was a meeting. We have a declaration given under penalty of perjury that says just the opposite of everything that the department is arguing. That declaration is attached to the verified complaint. It was provided in support of Compassionate's motion for summary judgment below. The department never deposed Mr. Patton. The department never got any conflicting declaration or affidavit from Mr. Patton to say, actually, I was wrong. Never mind. The city doesn't require this. The undisputed fact in the record, based upon the declaration of Mr. Patton, is that the city of Winslow did require documentation of local zoning compliance and would only issue it if the applicant had first obtained a conditional use permit. That's what the city said. That is undisputed in the record, and it's very important when looking at a Rule 56 proceeding that that fact to date remains uncontroverted. The department chose not to depose Mr. Patton. The department chose not to go get another declaration from Mr. Patton. They chose to rely on misinterpreted emails, patent hearsay, and subsequent meeting minutes. But what did Mr. Patton actually say during that meeting? We quoted in our briefs. He said, the city advised the state the CUP should have been obtained in advance. The conditional use permit should have been obtained in advance. To date, Mr. Patton has never changed his position. When we look at the email that Mr. Patton sent to Ms. Flores, he never says, my declaration was wrong. The medicine room has documentation of zoning compliance. That is not in there. It is not present in the email. So we have to look at what did the department have in front of it at the time that it made its decision in 2012 to reinsert the medicine room back into the lottery. We know it's undisputed. Documentation of zoning compliance was required to be provided from the city to the department. The applicant had to go get it and bring it to the department for that first step, for that registration certificate step. Mr. Counsel for the department just conceded that point. So there is not a two-step process for that documentation of zoning compliance. There is a first step, and then there is a second step. But that first step, they have to meet that prerequisite, and they did not meet it. The medicine room did not. And that's undisputed in the record. There is nothing, there's no declaration from Mr. Ferris or anybody else from the city of Winslow in the record. And the city decided that issue, not the department. And that was also conceded by the department. It was up to the city to decide whether it would provide the documentation. It was up to the city to decide whether or not a conditional use permit was required. The department chose not to honor that option that was left to the city during this process. And that is where the arbitrary and capricious and abuse of discretion actions took place. That is where the actions contrary to law took place. Now, with respect to the separate, that is one independent and distinct basis upon which this court has the authority to reverse the trial court's construction of the regulation and enter judgment in favor of compassionate. Nothing's going to change below. Del Patton's declaration isn't going to change. It hasn't changed. And it has been presented in a Rule 56 motion without being controverted. The record supports entry of judgment in compassionate's favor, and this is what we asked for. We asked that the court instruct the department to award a certificate to Compassionate Care because it was the only applicant in the lottery that had provided documentation of compliance with local zoning from the city of Winslow. And the evidence in the record with respect to the medicine room was to the negative. Mr. Patton's declaration is very clear. He says just the opposite. The medicine room does not have documentation of compliance with local zoning from the city of Winslow.
Because they don't have a CUP.
Because they don't have a conditional use permit. Neither the medicine room nor any of the other applicants were given documentation of compliance with local zoning from the city of Winslow.
You're out of time, counsel.
Thank you, Your Honor.
Thank you. Gentlemen, thank you for your argument. We are going to take the matter under advisement at this time, and we will issue our decision in due course. Again, thank you. We're adjourned.